So I'm just checking up on this. So the American probation is kind of a little bit different to in England. It's mainly they have to check in with probation officers or meet them just to have meetings to check up that they're behaving and that everything's going okay. But they can actually get unpaid work orders. It says that they can actually be given community service work. I think that's obviously with more severe offences. They probably likely get fined more in America. So they have it. They've got it. And actually, it says that usually some of the corrective measures they're given are more associated with the type of offence that it is. So, for example, if it is a drug program, the sentencing is usually in line with corrective measures. So, look, this is what I'm saying, right? And this is in England, right? It says that a certain percentage, at least, of your probation hours, you can claim any charitable work you've done for a charity where you've got evidence of hours of work for a charity or any good cause, unpaid work, good cause, you can get it taken off your community service hours or acknowledged towards it. Now, this is the argument in the first place. Petitioning, because there's a First Amendment right of petitioning, and because it's meant to be a good thing in the first place, which is why you would have some sort of immunity, we can argue over what the immunity does or doesn't cover under federal question law. But for at least, so the people that haven't managed to argue First Amendment protection for whatever they've done, who ended up getting sentenced and charged, whether that's a fine or anything under this community service order, the spectrum of whatever it is. So, on the premise that if they think that the type of behaviour for protesting, which is unacceptable protesting behaviour, such as, you know, the things that didn't qualify for First Amendment, you know, like, I don't know, smashing windows, trashing police cars and the rest of it, although in England at the moment, we've, under placing advertisements in public, we're looking at Gail Bradbrook's window breaking as possibly being a promotional activity as an advertisement, advertising the campaign, because it can be a theatrics, can be a representation under the Town and Country Planning Act through the use of enactment as Class F. But that's something that is going to be going to court apparently in September with Gail Bradbrook. But on the American, looking at the American situation at the moment, so this model they've got for probation, it seems like they like to get them doing things, corrective behaviour. So whatever area of activities you were doing, if you were doing something wrong, they like to correct your behaviour and put it right. So you should be doing the right kind of activities that you should have been doing, not the wrong kind of activities, but in the similar sort of area. That is what this is saying. I've just read it. I'm not wrong on it either, right? So on that basis, on that premise, what is a good and correct form of behaviour around the area of this petition, Stop Cop City? Well, the correct sort of behaviour is going around and collecting signatures. The correct behaviour is doing something good for a good cause. What does the law deem a good cause? Well, if it's something of First Amendment, of prestige and valour of your country, acting on behalf of the citizens of the state to better the country by getting the laws made or changed, even stopping Cop City, which the citizens are deeming. Who decides what is a good or bad charity? Who decides whether giving money to a dog home is good or bad? Who decides whether giving money to help the aged is good or bad? Who decides whether cleaning up the rivers and streams is good or bad? Who decides whether Cop City is good or bad? The people. So anything voluntary, volunteering, unpaid, for free, right, has to be good work if the citizens say it's good work. Who's signing it off? Who's signing it off as good work? Well, the person whose signature you get on the petition, surely. Now, all of the people who've been arrested or incarcerated or given community service or fined for misdemeanours in relation to Stop Cop City surely can have their convictions, orders or sentences reduced or discharged if they do corrective good work for Cop City, which is voluntary. Surely. So, what is the good behaviour? What should have you been doing? Going around collecting signatures, or this new thing they've got set up in the Signal groups, signature verification process. Now, they might be paying some people for doing that. Some people might be getting paid. I say that every person who volunteers for free, when you're collecting petition signatures, it is a non-profit engagement. You are not a commercial enterprise. You're not meant to be working for pay. If you are volunteering yourself for a petition, it isn't a company, and you should be. It's tax exempt. It's meant to be non-profit, a petition, because why are you collecting the signatures? Not for money, for an action from government. It's definitely non-profit. Every single person is an individual entity under 5013C. 501c3, illegal campaign intervention. No other citizen is meant to intervene in any other citizen's right to a petition. That's the point. This is why I'm complaining about the Signal groups where people booting you out of there or kicking you out of there when you didn't swear at anyone, you didn't use any offensive language, you just, one admin didn't like what you said or didn't see the genius in what you said or couldn't understand it, like Tay or Michael, ATL, or Blue. Oh, we don't understand that because we're stupid. Try and understand this. If you don't have admin in a petition group, don't have admin in a petition group. Why don't you have everyone equal? Because really, if you use a device such as a mobile phone to circumvent people from the group, you are pressing a button which results somewhere else in a person being disengaged from reading about the petition, seeing what's going on, or participating, right? So this is the point. The admins should not be removing anyone from the group. They should restore people unless there is evidence of bad language, swearing, or, abusive language or repetitive posting, like posting 10 posts in a row and spamming it, which just honest contribution, a honest question or suggestion is not. And out of all, it doesn't matter whether Signal's private or not. It's all about end user. And this is the argument with YouTube, and other things when they've got their election misinformation video. You can't use YouTube to obstruct people's democratic rights. It's end user. If you're sat somewhere, doesn't matter whether the group's private or not. The fact is, if you press a button and then another end user somewhere else is obstructed from any place that is being used for the petition process that they've got a right to engage in, it's obstruction. But anyway, I don't really want to that's not the point. Getting back to the main point, right? This is the main point. The main point is this. That signature verification group, currently, many people are doing it voluntary. And really, they shouldn't be paying them. And it's better if they don't pay them, because if they did get arrested or get community service, they could say they've been doing voluntary work on behalf of the people. What people? The people who've signed it. Who signed it off? The public. Who says it's a good cause? The public. And it's charitable when they're doing it for free. So, seeing as they've got not that long left to verify all these signatures, I would seriously, if I was we're the legal team, we're the voluntary legal team for the campaign. Well, why don't you voluntary legal team yourselves into the courthouse and get every single person who's been fined, arrested, incarcerated or whatever, the judge to give them corrective behaviour from doing things that are not constructive for petitioning, like smashing police cars, and then make them corrective behaviour by getting them verified and checking signatures. How would the city mayor like that? Corrective behaviour. It is voluntary work, so it's better if they don't actually pay them money for signature checking. It's better if, Wingo and Mr. Kastorf and Alex Joseph get them all compulsory signature checking, seeing that they need more people. That's my contribution towards it, saying that I aren't contributing anything. These are meant to be professional lawyers. You can get charitable work signed off towards probation hours. And who decides what that is? Well, it's negotiable, isn't it? So, get into the courthouse on your your federal question if, corrective measures of the right petitioning behaviour can correct the bad behaviour of the wrong petitioning behaviour. And then, once we've at least got them on the right petitioning behaviour, then we can discuss what isn't correct petitioning behaviour or not. And we'll see with the Gail Bradbrook case of smashing windows as a advertisement or a representation, a public display or theatrics to promote campaigns under advertising, if it classes as a representation in public or not. We'll see what happens in September, because that's something that they're halfway through now. If it can come under Town and Country Planning Act as an advertisement, painting does, because there's Class C for painting combined with Class E for elections and petitions, and Class F through the use of the enactment. Guess which enactment it is? The 1688 Bill of Rights Immunity Enactment. And if you deny that enactment to anyone, then you're subverting the liberties and freedoms of the realm. And who could possibly subvert the freedoms and liberties of the realm and deny those rights? Oh, federal judges, ministers, mayors, councillors, the city. And while I'm mentioning this, there's another thing as well, which is that what's the other thing now? This whole thing about getting the injunction or whatever to halt the work in the forest, in the Atlanta forest. Well, look, you can have a clause on the petition. If everyone who signed the petition is in favour of protecting the forest, then all of them are definitely in favour of protecting the forest. None of them are against it. So I would put to the court through federal question, can we add a clause to the petition which the city would have to comply with? And what clause might that be that you add to the petition? The clause that we wish to add to the petition is that while conducting this petition, can you stop the work on the forest, please? Put a halt to it. Can we modify the petition to add that clause in? Well, you can't really change petitions because you're changing what you're asking. Yes, but everyone who signed it is asking for them to save the forest. So why would adding a clause to the petition that the council will agree to halt all the work be against what the people have signed for? In fact, if the way it's going, they'll all have signed for nothing, for no reason at all, if by the time that it gets put onto the ballot, there's no forest left to protect. So it's a no-brainer. I mean, have these people even got an education? This is, questionable. Is this city impartial? Is this city representing the voters? Are they unbiased? Why are they wanting to try and take the petition to court when supposedly, it's not the city versus the public? It's the public who are for it against the public who are against it. That means that people who are against it have got equal vote in the referendum. There is no other party. The council aren't a party. Not in the decision. The council are the facilitator. The facilitator can only challenge the legitimacy of a petition if it was run legitimately or not. If it is faked, they can't challenge the decision or verdict the people make. In fact, I'm sure the council staff, even the mayor, might be able to vote in the referendum as one vote. Therefore, they can't have two representations as a citizen and as the city. They get their say in the referendum, surely. I really don't know what these lawyers are on in America. I think they're on like Coca-Cola, and it ain't Diet Coke. There's some serious issues. This is why the whole of America is a screwball scramble. It's messed up. Congress weren't too sure whether they should give the lower courts federal question power. It might give them too much power, so they took it away from them. They removed it, and then they gave them it back again. Several years later, 10 scores and 15 years, look at all the copyright claims that have been against using petition people's, using pictures and logos that people have borrowed for exhibits of evidence in petitions. You can't use my picture in that petition. I'm going to sue you for copyright. Well, I'd buy that for $1. Only when they give power to the lower courts and too many cases. It's like someone watered down a cordial too much and put too much water in. Now there aren't any rights, hardly. You got to beg for them. Beg for your rights, This is what happens when you give the lower courts too much power. I seriously think these people are in need of, some sort of intelligence test. It's like Eurovision, isn't it? I think America should be allowed to enter the Eurovision Song Contest. What's going on here? What's happening?